So thank you all for attending this CLE this morning. It's a 1.5-hour CLE. So you'll have your CLE forms in the folders that are on the tables or desks around the room. So we just ask that you fill out those forms, and then we can issue you the CLE credits after the program's concluded, and we'll get you those certificates quickly. So today's program is about issues in academic industry collaborative research, and there's a mix of people in the various offices. We have some university folks and we have some industry folks, and one of the goals of the presentation today is to start talking about the issues that arise that create some obstacles to getting collaborative research done between the private sector and the university sector, and allow everyone to understand what the issues are that the other party is actually facing. So we'll talk about the relationships, and then we're going to look at the legal issues with the relationships. And most of these legal issues are around the university side of things, because universities have lots of legal and tax issues that they have to comply with that industry may not appreciate when they're going into a negotiation over a research agreement or a licensing agreement after a research project has been concluded, to understand where the university is coming from. Some of these legal issues are going to affect publications, they're going to affect the intellectual property rights, they're going to affect the ability to give indemnifications and provide for liability protections. The conflicts of interests and public relations issues that universities will deal with when partnering with private sector are much different than the COIs and the public relations that you might get in a partnership between two private sector entities. And then there's issues around the use of facilities at universities, and we'll talk about those particular issues that, again, may not be always appreciated by the private sector when they're going in to talk with a university about doing some research. And then we'll talk a little bit more about the climate for engaging with industry, so different types of industry engagements, the different types of agreements that are reached for different kinds of situations, and what the basic terms are that accompany those kinds of engagements. There's written materials that I've put together in your packets. Obviously, the slides on the PowerPoint presentation are at the beginning. They have little note sections there in case you want to take notes on any of the particular slides. There's then a paper that I had written for the National Association of College and University Attorneys some time ago. It's just an excerpt of a paper that I did for them and a presentation I did to NACWA a while back that I thought was relevant. And then there's several exhibits, A, B, C, D, and E, which are part of the footnotes to the paper that I wrote. Two of those, the first two in particular, are from COGR, which is the Council on Governmental Relations, and it's an association of research universities. They are a really good resource for universities in terms of dealing with private sector and with government contracts. And these technology transfer and university industry relations brochures that COGR publishes are very useful. I found them to be very useful. And then at the end are tabs 1 through 7. And tabs 1 through 7 are predominantly examples of terms. Some are actually agreements, but some are just term sheets that some universities are employing now with alternate approaches to dealing with industry. Because there's been such a major push to get more research dollars in from the private sector, and there's been lots of issues trying to overcome the hurdles, particularly with intellectual property ownership between universities and private sector. There's a handful of universities that have kind of taken the bull by the horn, so to speak, and come up with some, what we would say, are creative options for universities and private sector partners to deal with. And we'll talk about those in a little while. By the way, can everyone see the slides as they're moving along? Is it all good on your screens? Okay, great. So when we start off looking at the perspective of these relationships, it's important to understand the cultures and the missions of the two parties that are involved. The university has a mission that really is diametrically opposed to the missions of private sector. University wants to create and disseminate knowledge for the public benefit or the public good, and they want to educate and train students. The industry obviously wants to maximize shareholder value. They want to create value for the owners and the investors. They do want to benefit the public through useful goods and services, but in a way that, again, maximizes the private gain for the owners. There's lots of benefits for the university to partner with industry, and those benefits shouldn't be overlooked, because this is part of when we're trying to structure a deal. We're trying to align these goals and objectives, and understanding what some of the benefits are that the universities receive when partnering with industry should be part of the overall structure of an agreement, or at least expressed in the agreement. So they get obviously they get the funding to support some basic and some translational research. They get access to cutting-edge technology that industry is facing, and industry resources and scientists that can collaborate with them, that they don't necessarily get to collaborate in their academic settings. It broadens the university's programs, all the educational opportunities for the students, and the research capabilities. Ultimately, if they're doing research projects, they generally develop intellectual property portfolios that can then be commercialized by industry. It helps to recruit faculty. There's some very entrepreneurial faculty in the engineering and sciences who very much like to partner with industry, and because of the incentives that those faculty have in doing that pursuant to the policies, the IP policies at the universities, some of them are very good, and it helps to recruit and retain those particular faculty members. And then there's obviously the economic development and jobs, which is kind of the third leg of the mission stool for the universities. Now, industry also gets a nice benefit when they partner with universities that they might not get from partnering with other private sector research partners. They're going to get really the top minds in the area. They're going to get highly skilled experts, and this is probably going to fill some gaps in their existing workforce skill sets. They're going to be able to get work done in laboratories that have equipment that not only is very expensive and capital intense to maintain, but it's probably stuff that they don't need in their own settings, because they wouldn't use it enough to make it worth their while. So they get access to these cutting-edge equipment and labs for testing. And then they help train the students that are going to become the workforce of tomorrow. And they get to learn more about how those students are being educated, and they get a little advanced peek at what the future employment is going to look like for their markets. So if we look at this through a Venn diagram, you know, industry has this mindset of a short-term return on investment. They like secrecy. They like to be able to inhibit competition. Whereas the university is always looking at the long-term advancement of the technological arts. They're looking at sharing information. They're looking at collaborations as opposed to keeping things under the hood. And then you have this small area of intersection. They both want a public benefit through the provision of useful goods and services. They both want educated workforces. And they both want to have highly trained experts solving problems. So the goal when we're trying to structure these relationships between the university and the industry is always to try to structure those collaborations in a manner that aligns with both of these parties' objectives. So if you focus in on the public benefit through the education, through the problem solving that can be accomplished through the use of these highly trained experts, and we pay a little less attention to the short-term ROI, the secrecy, the ability to inhibit competition, and vice versa, the sharing, the collaboration, and the long-term advancement, it's a little easier to get the deals done between the industry and the university. So what are some of the issues? And we'll go through all of these in more detail, but here's kind of a laundry list of some of the issues that we see when we have collaborations between universities and private sectors. A lot of the activities that the private sector is asking of a university could be considered contrary to the mission of the university. This has significant tax complications for the universities. And we'll go through the tax laws that are of importance in consideration to the projects that the university takes on with a private sector partner. And most of these are going to be tax issues. We're dealing with nonprofit tax-exempt institutions. There's not too many for-profit universities, and those that are for-profit are not out doing research. So the only universities that are out there doing research are nonprofit tax-exempt organizations. They might be land-grant, they might be technological institutes, they might be universities, and all of those different forms of higher education have slightly different missions and slightly different cultures to deal with. So if you're dealing with a state institution versus a private institution, for instance, there's going to be a lot more restrictions on what the state can do than what the private institution can do. If you're dealing with a land-grant institution that was created in the mid-1800s, whose mission was to advance the technological arts to enhance agriculture, that's going to be the focus of their mission. Private benefits, excess benefit transactions are some of the tax laws that are going to come into play, and we'll talk about those. A lot of facilities at universities are built using tax-exempt bonds. That's a typical financing structure for universities to create new facilities. When you have facilities created through such a financing source, there's a lot of restrictions on what can be done within those facilities. In New York State, there's a real estate tax exemption that the universities benefit from. If they start making private business use of those facilities, they can lose that tax exemption of the facility. So even if it's not financed through a tax-exempt bond, there still could be restrictions on what the university can do within the facilities, pursuant in New York State anyway, in order not to lose the tax exemption on the real estate that building sits upon. Sometimes you do have UBIT, unrelated business income tax issues. So sometimes what the university is doing will be outside of its mission, and it's going to have to claim unrelated business income tax on that and pay tax on whatever the income stream is. Obviously, that makes it much less competitive, because now if it's doing the work essentially at cost and it has to pay tax on top of that, it's going to be losing dollars. It's not going to be able to operate very long in that particular model. Some of the other legal issues. The loss of academic independence. It's very important as part of the mission to ensure that academic independence is maintained throughout the collaborative relationship. The confidentiality obligations that are often imposed at the outset of a research project, even preliminary to a research project when they're in initial discussions, can be questioned in terms of the ability to maintain that academic independence. We'll also look at that from the angle of the drafting of a statement of work, which is kind of the heart and soul of the research agreement, where we're delineating what it is that's going to be done pursuant to the collaborative research engagement. The loss of intellectual property rights. This can have a significant impact on the university as well. A lot of, when you have some industry coming into a relationship and maybe the private sector company hasn't dealt with universities before, and they go in with the mindset that we're paying them to do this research, any intellectual property that's developed as a consequence of that research, we're going to own. And that's our mindset going in, and that's the way we're going to negotiate this thing. That will result typically in a stalemate. We'll talk about the intellectual property rights and some of the reasons why universities generally have to hold title to the IP. We'll also look at those, like I said, those exhibit tabs in the handout materials, which are examples of a handful of universities that have departed from that model, and we'll look at those. Conflicts of interest are much more important, obviously, in a academic setting. You have research integrity issues. You've got private conflicts of interest where the faculty member may have some financial stake in the results of the research. They may have doctoral students, PhD students that are working for them that don't realize that. It's very, very important for the conflicts of interest to be disclosed early, and it's very important for them to be managed properly. Just because there is a conflict doesn't mean you can't go forward with the project. It just means you have to manage the conflict. And in order to manage it, you have to know about it. So it's very, very important. And it's beneficial for both parties, the private sector party as well as the university, to have those conflicts of interest disclosed early and managed properly. Public relations issues, generally speaking, universities will not permit publicizing the collaboration. It'll be very rare. It may be some joint press release down the road if there's a big hit, but generally there's not going to be a lot of press or a lot of publicity around the collaborative research. And then there's financial issues. Universities have accounting practices that are much different than what you would see in the private sector. They have lots of costs and expenses that they have to account for and deal with that private sector companies do not have to deal with. So sometimes you see the payment schedule or something in a research agreement and it looks foreign to the private sector party because they're not used to seeing a 47% overhead charge or an indirect cost expense line item for fraud and abuse compliance, things like that. So you have to understand the accounting practices that go into the university's budgeting on these research agreements and these other kinds of collaborations. So looking at these issues, so the tax considerations, the nonprofit tax exempt issues. Universities are not-for-profit institutions. Most of them get their tax exempt status under Section 501c3 of the IRC. Some of them have tax exempt status through some other statutory basis, but most of them are 501c3. That means they have to be organized and operated exclusively for an exempt purpose, and not more than an insubstantial part of their activities may be for non-exempt purposes. At the outset, when industry and universities first started working together on collaborative research, universities originally were only doing research for the government. It was a very rare situation when they were actually doing work for private sector, but certainly over the last 40 years or so, it's become much more commonplace, and it's becoming more and more commonplace because of the drying up of the budgets through the federal agencies that traditionally supported fundamental research. But when they first looked at them, they said, this is not exempt. This is private business. When a university is partnering with a private sector institution for purposes of doing research that is then going to be commercialized by the private sector. This is just a commercial relationship. So those were considered not to fall within the exemption, which was a problem because it could jeopardize the tax exempt status of the university, which is obviously critical for the university to maintain. Laws and regulations were passed, and they are now considered, well, and they have been for quite a long time now, industry academic partnerships are now considered exempt activity, but only if these conditions are met. They're exempt if the partnership is carried on in the public interest by making the results available to the public on a non-discriminatory basis, or that the partnership is directed towards benefiting the public. So if, for instance, a partnership is carried on, there's publication restrictions that prevent the dissemination of the knowledge, and perhaps confidentiality restrictions that prevent the findings of the research to benefit the public, and perhaps the university gives up its IP rights, so now it has no ability to control what happens with the technology that's now been protected under the intellectual property laws, and the private sector could just shelve it, right? They could just put it on the shelf and it could never see light of day, and there's nothing the university could do about that. That's problematic from the university's perspective, because now that partnership does not fall within the rules for being an exempt activity. So any of the monies that were received as a consequence of that relationship should now probably be going through the counsel's office or the accountant's office for tax treatment. And worse, if it's carried on in a tax-exempt bond finance facility, now the university is going to have to make the bondholders whole by giving them the extra money because it's not going to be tax-exempt anymore. And it would be devastating. Not only, you know, we'll talk about tax-exempt bonds later, but certainly if that was ever to occur in a university setting, not only does the university lose a ton of money because it's going to have to make the bondholders whole, it's not going to get financing in the future. Or if it does, that financing is going to be way more expensive than it was this go around. Their debt obligations are going to go through the roof. So they really can't risk that kind of activity in a facility that's been financed through tax-exempt bonds. Private benefit and excess benefit transactions. Now these also come into play when you are doing collaborative research with an organization that happens to have you know, with excess benefits transactions with a disqualified person, and we'll talk about that in a moment, or simply for the benefit of a private party. So an organization will not qualify for exempt status if it confers more than incidental private benefits, or if any part of the net earnings of the organization inure to the benefit of any private shareholder or individual. Frequent, significant provisions of goods or services by an exempt organization where the exempt organization receives less than fair market value may result in prohibited private benefits. The penalty, if the IRS were to determine that a college or university had violated the private benefit rules, it's the revocation of the institution's tax-exempt status. And it doesn't take too much thinking to understand that if a university or college loses its tax-exempt status, it's essentially out of business. It can no longer operate. It's no longer going to be able to teach students. It's not going to be competitive anymore because it's going to be paying taxes, right? So rolling of the dice on collaborative research projects where private benefit is given is a tough decision for a university to make. Do they want that $1 million grant and give away all the IP, which is probably a private benefit, and they want to sell it to them before they even know what it is, before the research is done, at the outset of a research project, and they sell it for $1 million or they sell it for $2 million and it turns out to be a blockbuster that's worth, you know, $25 billion? The IRS may not look kindly on something like that occurs. Those were tax dollars at work. And the penalty is severe. It's the revocation of tax-exempt status. And that's why most universities have not moved in the direction of these handful of universities that I've provided examples of in the back of the handout materials in coming up with these novel approaches to deal with the intellectual property ownership issues. At the outset of a research agreement, generally speaking, you do not know what's going to come out of it. And we're going to talk about structuring a statement of work in a little while. But research is very, very unpredictable. You don't know if it's going to lead to anything or not. From a faculty perspective, that's the whole reason for doing it. From the university's perspective, they need the flexibility. They need to go where the research leads them. They can't go with a mindset of having a concrete deliverable at the end of the day. And if they're doing that, then they do look like a work-for-hire situation. They just look like any other private contractor out there doing work for the private sector. They don't look like a university that's pursuing academic curiosity or intellectual curiosity, which is what the mission is. So it's very, very difficult for them to actually do the kinds of things that most institutions to reduce the risks on their side are looking for. And that's where you get into some loggerheads in the negotiation process. And again, we'll talk about that. Excess benefit transactions are a little different. Now, an excess benefit transaction occurs if an organization enters into a collaboration with a disqualified person. And a disqualified person has a definition under the Internal Revenue Code. It's a trustee, an officer, or anyone else who, during the 5 years preceding the transaction date, is in a position to exercise substantial influence over the organization. So it could be Phil Knight from Nike entering into a deal with the University of Oregon, since he funds 90% of their athletic budget. He has substantial influence over the University of Oregon. So if he went to the University of Oregon and said, I want you to do some research for me on some new rubber compounds for the soles of our sneakers, and I want to make sure Nike owns all the intellectual property that comes out of that because we don't want Adidas getting a hold of it. So go ahead and do it, but make sure we have all the IP. That could be an excess benefit transaction. I don't know if he's a trustee or not, but he's certainly a person that has substantial influence over the university. So if you give disqualified persons right to use the IP or other results of the collaboration on a below market basis, that's a problem. Now, Nike could do that with the University of Oregon, so long as they're just doing a sponsored research project, and then at the end of the research, if something comes out of it and Nike wants a exclusive license to it, they negotiate for the exclusive license at an arm's length transaction, and they pay the same rate that Adidas would pay if they were the ones going in and trying to negotiate that license. But if Nike goes in and gets it for, 1 cent on the dollar, that's a problem. That's a below market rate. Now, the excess benefit transaction penalties are not the revocation of tax exempt status like private benefit transactions are, but it does result in substantial tax penalties to both the university and to the individual, the disqualified person who receives the benefit. So they too are penalized as a consequence of having entered into that transaction. Tax-exempt bonds we spoke about very briefly. The tax-exempt status of the bonds might be lost if the facilities that were constructed using tax-exempt bonds as the financing vehicle are used for private business use. And the nonprofit borrowers are permitted only a nominal amount of private business use. For a 501c3, it's 5%. For other tax-exempt organizations that aren't organized under 501c3, I think it's 10% of the total use of the facilities. So they're very, very strict in the accounting practices that are ongoing in these facilities. And it may be, maybe a 10-year term, it may be a 20-year term, it could be a 50-year term. I don't know what the term is on a particular bond for a particular building, but sometimes these bonds last an awful long period of time. And the research that's being done, and then when they're first built, they're obviously cutting edge, and that's when they're going to get, the biggest hit of activity is in those early days. So it's going to be at a period of time when those tax-exempt bonds are still in force, and you have to abide by these rules. Once the bond has been paid off and retired, you're not under those restrictions anymore, right? But you still have the real estate tax exemption, at least in New York State, and I would think most other states have very analogous types of rules that New York State has in it. But regardless, with the tax-exempt bonds, when your private business goes in, they may not realize that the labs and the equipment that they want to take advantage of at the university happen to be situated in a building that was financed using tax-exempt bonds. And it just might not be an issue to them. And even when they go into the relationship, it may not be on the top of the minds of the university to say, oh, by the way, just to let you know, these labs are situated in a building that we financed using tax-exempt bonds, so there's restrictions on what we can do there. So it may not be, if the two parties aren't talking in that regard, there could be lots of misunderstandings. So it's just good to know that this is a potential issue that you could face when going into a negotiation with one of these organizations. The real estate tax exemption, it's Section 420A of the New York State Real Property Tax Law, and that proposes that real property owned by a corporation organized or conducted exclusively for a hospital or educational purpose must be used exclusively for carrying out to qualify for a tax-exempt status. uses other than that subjects the real property to taxation. So an educational purpose, obviously it's going to be consistent with the mission of the educational institution. So now if the laboratory on campus that's being used to conduct the research is being used in a manner that's not consistent with the tax-exempt purpose, now the university is facing the potential for having to pay real estate taxes on that property rather than receiving the exemption that it otherwise qualifies for under the not-for-profit tax laws. That too can obviously be hugely detrimental to the academic institution. UBIT, unrelated business income tax, imposed on any unrelated business taxable income, and it's based on the gross income that's derived by the organization for any unrelated trade or business. So now if a university is entering into a relationship with private sector and it looks more like a work-for-hire type situation, where the private sector is simply entering into a contract with the private sector party for doing some research and giving the research to them, maybe taking confidentiality restrictions, then the university should be paying UBIT on it. They should be paying income tax on that gross income that's derived from that, if it's not substantially related to the exercise or performance of the exempt purpose. There are safe harbors that are built in to the Internal Revenue Code, and this is what most universities abide by. Most universities will try to stay within these safe harbors. And again, when a private sector party is coming to the tech transfer office or to the Office of Sponsored Programs, whichever office on campus is responsible for administering these relationships, it's probably not something that the university tells the private sector party that, by the way, we want to operate within these safe harbors that the Internal Revenue Code gives us. And it's not something that the private sector party probably realizes even exist. They probably don't realize that there's some restrictions that the university is trying to stay within the confines of in terms of the relationship. So then they start negotiating, and again, they come to loggerheads over intellectual property ownership or over confidentiality obligations. And there's a reason for it. And it's much better if we go into these negotiations and into these collaborative research efforts with an understanding that there are some restrictions, and it's not one guy or one person being mean and nasty and, you know, inflexible. There's reasons. So just having this education of understanding that there's reasons behind it is very important. So the technology and intellectual property resulting from research has to be licensed on the same terms as a non-sponsoring party would get. And they refer to this as being competitive pricing. So even if you're the sponsor of a research project, in order to get an exclusive license to the IP that comes out of that research project, the university, in order to stay within the safe harbor, really has to enter into an arm's length negotiation with you over the royalty rates. It has to be competitive in terms of the pricing. So again, using the Nike and Adidas example, whatever Adidas would pay, even though it didn't sponsor the research, is the same rate that Nike should be paying. If Nike's paying something substantially less than that, they're no longer within the safe harbor and the IRS could come knocking at the door. The pricing for the license, and this is another key issue. The pricing for the license has to be determined at the time that the IP or the technology actually exists. And this is why most sponsored research agreements will not have license terms as part of the agreement. It'll have an option to negotiate an exclusive license generally, and it might even give a non-exclusive royalty-free license to use, what they refer to as a NERF, but it's not going to give exclusive rights to it in the SRA. And the reason is they don't know what's coming out of that research. If they already knew about it, it's really not fundamental or translational research anymore. And it's probably not part of the exempt purposes of the institution. Universities are doing fundamental research, they're doing some translational research. When they do fundamental and translational research, the whole point of it is you don't know what's going to happen. That's why the research has to be done in order to learn it. Sometimes it goes through and theories prove correct, and you get some really great technologies, and you get some great IP around those technologies, but you don't know what it is at the outset of the relationship. Pursuant to the safe harbor, you can't price that intellectual property until it comes into being. And it's not going to come into being until the research has been done, or at least you're so far into the research that you now know what it's going to look like. That's why you can't have, you know, in a lot of universities or industry, when they go into these sponsored research arrangements, if they haven't dealt with universities a lot in the past, sometimes they get very frustrated, saying, look, we're paying, you know, $100,000 or $1 million or $5 million for some sponsored research. We want to know that we have a license to this at least at the end of the day. If we don't have ownership, we at least want to have the exclusive rights to it. And there's a reason why the university can't do that. And this is it. The university wants to stay within the IRS's safe harbors. The university in the, yes?
Does it violate the tax code though?
No. No. The non-exclusive royalty-free license does not. Not all universities will offer it, but in my experience, most will. But no, the non-exclusive use of it doesn't, because the university still has the ability to go out and commercialize it otherwise. So say, for instance, that the industry partner, again, they don't want to make use of the technology. They have a competitive product ultimately, and they don't want to cannibalize that. So non-exclusive isn't going to give them the ability to prevent that from happening, right? So again, we can still have a public benefit at the end of the day through other relationships. The university and the principal investigator have to determine the research protocol to retain title to the intellectual property. So the university and the PI are the ones that are going to dictate how the research is done. The company's not going to say, this is the way we want you to do the research. You have to follow this particular protocol. And there's lots of reasons for that go into other areas, especially with human testing or animal testing, in terms of what the universities have to do to abide by research requirements that NIH might have or other government agencies might have in order to carry out certain types of biological tests. The Internal Revenue has two rulings, 97-14 and 2007-47, that provide these particular safe harbors. Issue number 2, freedom to publish and confidentiality. Obviously, the university's mission to impart knowledge and to enlarge humanity's store of knowledge through publication benefits the public, and the tax-exempt status is to carry on scientific research in the public interest. Private industry generally wants to secure a competitive advantage from the results through confidentiality terms, through publication restrictions. There's at least 2 legal issues to understand when it comes to negotiating the confidentiality. One is the tax issue, and the other is an export control issue. So under the export controls, the research is basically exempt from export control laws if it's publishable. And that's what they call the fundamental research exemptions. Universities enjoy a great benefit by having a fundamental research exemption. But they lose that exemption if they accept significant restrictions on publication. So if they agree not to publish, they no longer have that research exemption. So now, if the information is something that can be export controlled, there's lots of restrictions on who can see that, who can touch it, and what has to be done with it to preserve the export control requirements. Most universities are going to have some guidelines on sponsored research concerning publication. It's going to include the ability to publish the research results. They're not most, in the examples in the back, there's one university that at least says it'll accept restrictions on publication, but I've never ever seen a university accept a restriction on publication. It's generally not acceptable to universities. They will be giving industry periods of time to review and maybe extract certain types of information from a publication, a 30-day review period, but it's not going to be, the publication is not going to be controlled by the industry partner. And you can get additional delays if you're seeking patent protection. in order to get that done, but it's going to be some reasonable period of time, like 60 days or 90 days. It's not going to be, well, keep it secret for the next 6 years so we can get our patent application on file. It's going to be some relatively short period of time. Universities should be reviewing these research agreements to make sure that they're not restricting publication, and researchers, PIs, shouldn't be entering into side deals with industry partners to say, don't worry, I'm not going to publish that, and signing individual agreements. What do the confidentiality clauses include, and some of the issues? What needs to be marked? Does it have to be marked at all, or is everything we're discussing find itself subject to confidentiality? Are there going to be students that are going to be involved in this project? Universities generally will not bind students to any contractual obligations. They don't control those students, especially after they leave campus. And they would, they're not going to bind themselves to a contractual obligation based on a student who then goes to work for a competitor of the company that is doing the sponsored research, for instance. The university isn't going to take that kind of liability on. Trade secrets. Universities do not want industry partners to divulge trade secrets to them, if at all possible, in order to carry it out, because that can affect their ability to publish, or it could impact liability if they were to publish. So they generally will, and it also could have export control restrictions associated with it. So again, for lots of reasons, trade secrets are generally something the university doesn't want to know about in terms of the industry partner. There's lots of attempts by industry to backdoor the prevention of publication. The ones I've seen most commonly are the agreement defines company confidential information or confidential information, whatever the term is, to mean all information provided by the sponsor or related to or derived from the sponsor's information. So essentially, that would encompass everything that's being done under the sponsored research agreement. And then somewhere later on in the agreement, maybe 3 or 4 or 5 or 10 pages buried later on, you'll have this publication restriction that says the university is free to publish results. So it looks really good, arising out of the research, provided no CI is disclosed. So now you go back to the definition of CI, and essentially everything done under the research agreement is going to be deemed CI. And that's the way slick industry partners try to prevent publication, and some universities that may not have been paying close enough attention to the definitional sections in the agreements could fall prey to having restrictions placed on publication. That's going to impact the fundamental research exemption relative to that. It could be a breach if the professor doesn't appreciate the fact that they couldn't publish and they go and they throw it into some scientific journal, and the university gets sued for breach of contract. So it's important to pay attention to the definition of CI and how that impacts publication, because usually those two things are not near one another in the actual agreement language. They're usually several sections apart. Ownership. University owns all IP created by a faculty member, which is made within the scope of employment or made with significant use of university resources. That's generally the rule. And a company would own any IP rights where the company employee is an inventor. So ownership generally follows inventorship. Ownership and inventorship go hand in hand. Company and university would jointly own where both parties have conceived of whatever the invention is that becomes subject to the intellectual property rights. So that's the general standing rule. Now, there's been some novel approaches to IP. The traditional is no pre-negotiated exclusive right or ownership right. Option to negotiate exclusive licenses after the research is done. That has been the long-standing traditional approach of virtually all universities that do research. Now we're starting to see these pre-negotiated exclusive licenses where the company will pay some upfront payment, maybe 10% or 15% of the research budget. So if the research budget is $100,000, they'll pay another $15,000 in order to have a fully paid up exclusive license. So they'll have some upfront payment. A pre-negotiated assignment. It's the same idea, except generally the charge is a little bit higher. And then the way the universities protect themselves in essentially giving away the IP up front before they know what the true value is they put these Bonanza clauses into the contracts. A Bonanza clause is simply a clause that says if you make a ton of money off of this in any given year, when you get over that ton of money level, whatever that predetermined number is, you will pay us a royalty for the remainder of that year. Usually it's a really big number where it's not likely going to hit ever. So the company is generally comforted in the fact that it's not going to be paying royalties to the university beyond what it's paying in the upfront number. But if it happens to be a blockbuster, so be it. They've made a lot of money and they don't mind paying a little bit more to the university as a consequence of the use. And the university doesn't feel as if it's given it away well below market value. Like I said, go ahead.
Question in Rochester?
Yep, go ahead.
Have these more novel approaches been tested from an IRS perspective?
No, and that's what I was going to mention that. Because there's more universities doing it today than ever before, you know, I would say Penn State was probably the first one to start it. And when Penn State started it, it was an option, but it was only used in really narrow circumstances such that it was essentially never used. But then, you know, Penn State started using it more. University of Minnesota followed. I think Oregon State, Purdue. You know, there's a few other universities now using it, and I've given the list in the written materials. Not all of them are in there, by the way. RIT does it now, and RIT is not in that list, as an example. Clarkson has it, and Clarkson's not in that list. But I do know that in talking with some of the in-house counsel at these universities that do offer it, believe it or not, there's very few industry sponsors that actually take advantage of these other approaches. Most of them are still going with the traditional approach. Because if, you know, the mindset is they're going into the research project, they want some guarantees that they're going to have exclusivity, but they don't want to actually pay for it up front. You know, what they really want is exclusive rights, guaranteed exclusive rights, and if they happen to make money on it, they'll pay for it then, but they don't want to pay for it up front. So all of these deals do require upfront money, so it increases the risk, the cost anyway, from that perspective, and most of the industry partners anyway have not taken advantage of these alternate approaches because they still end up at the mindset of, well, okay, all right, we have this option to negotiate the exclusive, we will negotiate, we know we have a right of first refusal, or we have the ability to get reasonable terms, and that'll be good enough for us because we'll end up paying it only if we actually commercialize and are successful with it. So we're not going to spend more than what we need to spend on it in that sense. So even though these approaches have been out there for a few years now, the experience of the universities that are offering it has been that the industry sponsors are not actually taking advantage of it anyway. Even though industry was clamoring for it, but now that it's given to them, they actually don't want it. They want to go back to the original template model. Now, why does the IP university want to own the IP? Well, first and foremost, it's going to prevent disruption to a line of research. Most faculty members are doing research in one given area for 30, 40, 50 years. And if they give away a key piece of IP, and if it happens to be a very broad IP that they give away, it could impact their ability to do research going forward. It may be, maybe they still have the right to do research internally, but because they don't have the ability to create improvements on that with other industry partners, it can prevent their line of research. It can disrupt it. That's a big, big reason why the university doesn't want to give it away. Bayh-Dole, which we're going to talk about with government funding. Bayh-Dole requires the university to maintain ownership. It's a statutory requirement. If there's $1 of federal funding involved in a project, the university is prohibited pursuant to law from assigning it. So we'll talk about Bayh-Dole. They need to be able to recuperate costs through royalty or licensing fees and dump that money back into the nonprofit mission. They can use diligence milestones to make sure that the technology isn't being shelved. They can maximize commercialization through non-exclusive licenses or exclusive with field of use restrictions. So they might have a new drug that's beneficial to animals and humans. And so they might have an exclusive partner in the animal world and an exclusive partner in the human world. Whereas if they gave exclusive without any field of use restrictions to just the company that does the human treatments, now animals are suffering as a result of not being able to get the benefit of the technology. So they can do a better job of maximizing the public benefit. And they avoid tax complications, obviously. Inventors and creators of the university. Bayh-Dole requires the university to have a policy in place that shares royalty revenue with the inventors. This again goes to that retention, ability to retain top faculty, research faculty. Some top research faculty at institutions are multi-millionaires as a consequence of the royalties they've received pursuant to the inventions they've created pursuant to sponsored research. Because they get generally 50%, most universities it's 50% of the royalty income after costs are paid. 50% goes to the inventor, and then 50% is split between the university and the college, you know, however the university does their division. But usually about half of the royalty income goes to the PI, the inventors. If you receive some federal research funding, which still the biggest amount of research dollars coming into the institutions is from the federal government, there's a condition of the funding in the patent policy that it complies with the Bayh-Dole Act. All industry contracts must also be in compliance with and consistent with Bayh-Dole obligations to the extent Bayh-Dole is applicable. So whenever there's $1 of federal funding, it might be pass-through funds where the research is collaborative with not just an industry partner, but perhaps with a federal agency. Or maybe the university is a subcontractor on a federal agency agreement and has some pass-through dollars that are being used in that lab. You have to have Bayh-Dole compliance. Bayh-Dole is a law that came about in 1980 that gave title or allowed universities and nonprofit institutions to retain title to intellectual property that arises under federal grants. It used to be the federal government would own title. And the federal government developed this huge portfolio of patents that it never did anything with. It just sat there and gathered dust. And Birch Bayh and Bob Dole passed this legislation in 1980 that said that's silly. The government doesn't want to commercialize. They want the research done because they want to build better weapons and they want to build better safety and things like that. But they don't want to commercialize. So let's give title to the universities that are doing the basic research. Let them commercialize. The university has to give the government a license back, a confirmatory license, so that the technology can be used by the government, but the technology can also be licensed to the private sector. There's lots of conditions on it. Some of them are listed there that the institution has to abide by. One of the more important benefits under Bayh-Dole, or one of the more important aspects, is that they have to collaborate and commercialize with firms that utilize the inventions. It has to be a U.S. business, and they have to give a preference to small business. I just represented one university client that had a spin-out that we had licensed the university technology to, and the spin-out was just recently acquired by a European company, and the European company wanted to own the IP. But a lot of the IP had been developed under federal funds. And it was a problem, right? I mean, it could have held up this acquisition. Ultimately, we were able to get waivers from the federal government agencies in order to sell these patents. But because of Bayh-Dole, there were obviously restrictions on being able to transfer those patents. But the spin-out, having been sold and it retained jobs in this area, you know, there were good reasons for the government to give the waiver, but we had to go through that process of getting the waiver. So sometimes it can be problematic, but you have to make sure you're complying with it. $1 is all it takes. So if there's a single dollar of federal money involved in a research project, Bayh-Dole applies. You cannot assign the subject patent rights to industry without the funding agency's permission, and you have to share the royalties with the inventors. Liability issues. Negotiating indemnification provisions with a university is a lot different than negotiating indemnification provisions with a manufacturing partner or a research partner. The company's obviously going to want to minimize legal risks from collaborating with the university. They're going to want the university to agree to mutual indemnities. They're going to want the university to indemnify for liabilities from the research and the use of the results that result from its acts or omissions. And it's going to want the university to demonstrate that it has insurance to cover these potential liabilities. The university is going to want to protect its operating budget and its endowment from any unnecessary risks. It doesn't want to have exposure from the company R&D and commercialization efforts. And it's going to want indemnification from the company for conduct of research and the use of the results. And it's going to want the company to demonstrate it has insurance to cover these potential liability risks and obligations. It's generally not going to want any indemnification obligations on itself. And if it's a state institution, generally state law prohibits it from giving indemnification. So if you're working with the SUNY Research Foundation or Penn State University or any other state research institution, generally there's going to be lots of restrictions on the types of indemnification that the institution can provide. And it's not so much we don't want to give it to you, we can't. There's laws that prohibit us from doing that. So it's important for the companies to understand that. The reciprocity of obligations, the scope of the indemnity is going to be very narrow. And you know, usually if there's some negligence on the part of the university, that's something that usually can be covered, or a willful misconduct of a university. But again, the indemnification is going to be much more restrictive than it is in a private sector type arrangement. Conflicts of interest. Again, I talked about this at the outset. Conflicts of interest are, you know, it doesn't mean the project can't go forward, but it means they need to be disclosed and they need to be managed properly. And full disclosure is always going to be key. The disclosure has to be made immediately. You know, every university has an annual report for conflicts of interests that its employees execute, especially its PIs. You don't wait for that annual report. If a conflict is potentially arising, they need to know about it. So if you're a small company, maybe a startup, and maybe one of your shareholders or one of your partners in that startup happens to be the PI, and then you're going and you're getting the sponsored research agreement, it's beneficial. Let the university know. If you're on the private sector side, say, by the way, Professor Jones is one of our shareholders, by the way, and we're using him as part of the sponsored research here, okay? Just so you know. Because it can result in big problems down the road for both parties in holding up the commercialization of the technology, litigation and whatnot. It's beneficial to both parties to have an active and robust management of the conflicts. Public relations issues. The university needs to protect its name, its brand, its reputation. It doesn't control what the company does after you know, there's no relationship anymore. So maybe a company is a research sponsor and they publicize the heck out of it, saying, you know, such and such university is partnered with such and such company and it's a great relationship, and then, you know, a year or two down the road, that company is found to have violated securities laws, insider trading, sexual harassment, whatever it happens to be. Now it's going to negatively impact the university as a consequence of that publication. So most universities are going to prevent any publicizing of the relationship. There's not a big benefit to be gained, really, from either party in publicizing it, and most of the time it's not too big a deal. But a lot of times, the smaller companies in particular really want to publicize the relationship because it adds to their credibility. But the universities really need to be insistent on minimizing the amount of public relations that are done. Budgeting, financial considerations. The university needs to cover all of its costs. There's direct costs of the research. There's reporting costs associated with the research. There's indirect costs. There's fraud and abuse compliance costs. There's lots of line items that go into a university's budget on a research project that are probably not common for a private sector party who's not familiar with university budgeting to understand. And the costs add up, obviously. And so a research budget, you might say, well, this is a $100,000 research cost. All of a sudden, it's a $200,000 research cost because of the F&A compliance or because of the indirect costs that are also incurred. Now, when you're dealing with the budget, we'll talk about this in a few minutes, but it's very important to align the costs of the research project with a timeline in the research agreement. So best if the costs are incurred when they're truly incurred and the payments are made when they're incurred. So if you can do the budget such that it aligns with the timeline of the research project, that's always best. So if we look at the overview of these agreements, the heart of the research agreement is going to have a description of the project. It's going to have the identification of the key personnel. It's going to have the duration and timeline associated with the activities that are going to be conducted under the research agreement. It's going to identify the location and the facilities, what the cost drivers are, what any special resources are. So if they need to get, 600 fetal pigs in order to do animal tests, that'll be identified in the heart of this document description. The scope of work, the SOW. This needs to be carefully drafted from both parties' consideration. The university wants this thing to be open-ended. It wants it to be defined in terms of the effort the university is going to be putting in. Industry, they want concrete, direct deliverables. That's very difficult for a university to abide by. If the research takes a turn, an unexpected turn, that's the direction the research has to go. It may require an adjustment to the timeline. So the very bottom bullet point there, can you extend the timeline or change the scope? There should be a provision in that statement of work that allows that to happen because of the unpredictability of research. Are all the personnel and equipment actually available? Can you get those labs? Does the PI that's going to be responsible for this actually have the time, or is he also or she also working on 7 other research projects that are going to take precedent over yours? High-level, open-ended discussion of the deliverable versus something concrete. Again, the university would prefer something more higher level, something more open-ended to allow the research to go where the research is going to go. By the way, if you're working with foreign entities, I had one research agreement I was working on with a company in Brazil, and scope of work was given the acronym SOW, and so when they translated it everywhere SOW, it said female pig because of the translation issues. So be aware if you're going to abbreviate certain things and it's going to get translated. We were wondering where the female pigs came from, but then we figured it out. It was always where SOW appeared in the document. Payments cover all the direct and indirect costs. Are there costs that can't be canceled? So if, for instance, you're committed to buying some biological materials and you have to already buy those, and then it turns out you don't need them, well, now you've got some costs that can't be canceled that you still are going to incur, and that needs to be understood at the outset. You should try to ensure that the payment schedule aligns with the timeline for the incurrence of the costs to the best of your abilities. You need to understand, the industry in particular needs to understand, is the university going to be using funds from any other sources for purposes of completing this research project, especially if there's federal money, pass-through money, SBIR money, STTR money. Any of that kind of money coming into the research budget is going to impact, again, the ability to commercialize it later on. And then what's going to happen to the equipment? Is there special purchases of equipment? And if there is special purchases of equipment, what's going to be done with that equipment at the end of the day? The delivery of results needs to be specified with a good level of detail. How are they going to be delivered? Is it going to be oral only? Are there going to be written reports? What is the detail level in those written reports need to be compliant with? Does the industry get access to the key personnel to interview them and ask them questions and go over it? What are the expectations? Make sure the expectations are clearly set forth in the statement of work that's dealing with the delivery. Are the time commitments flexible or are they concrete? You have to give us a report on the 1st of every month, or the 1st of every month, or as soon thereafter as they reasonably become available, something along those lines. Are there issues with internal review board consents? Are there HIPAA issues with healthcare data? Are there export control issues associated with the delivery of the results? So obviously all of those aspects need to be taken into consideration. Special arrangements now. Company researcher uses university facilities. This has tax implications, nonprofit implications. The university should be using what's called a visiting scientist agreement. I'll briefly discuss VSAs in a moment. But the goals of the VSA, they outline the permissions that are granted to and the restrictions on the use of the university facilities by the visiting scientists. They're going to require compliance with all university policies and procedures, including any training requirements, university research policies, and any contractual commitments that might be on the use of that particular facility. Confidentiality and publication expectations need to be clearly set forth because they could differ significantly from what the company is used to. The company's IP rights and the university's IP rights should be clearly set forth in that VSA, even though the scientist is an employee of the company. If they're using the university facilities, is there a change in the contractual obligations to assign? The legal relationship should be set forth. So from a labor standpoint, are they an independent contractor? Are they an employee? What are the labor implications of that visiting scientist with the university? When a university researcher goes and uses a company facility, the same considerations have to be taken into account. The company is generally going to present the university researcher with something to sign, and it's generally going to be very favorable to the company. It's going to say the company is going to own all the intellectual property that arises out of any results that occur using the company's facilities. It's going to say they can't publish anything. It's going to say there's no rights that the university is going to garner. And a lot of times these are entered into with the faculty member individually, not necessarily the university. This is what happened in Stanford versus Roche, which was a fairly significant Supreme Court case, where Stanford University ended up suing Roche for patent infringement and losing, because the PI in the case actually went and did a visiting gig with the predecessor company to Roche that Roche subsequently acquired, and signed a visiting scientist agreement with the company's version of it, and agreed to assign the IP rights to the company. So it turned out Roche actually owned all the IP that Stanford thought it owned, and it had sued Roche for infringement of the polymerase chain reaction technology that scientist had developed at that company. Probably cost Stanford University hundreds of millions of dollars in royalties because it was very, very significant technology. University is going to want to try and use its visiting scientist agreement. Again, universities are actively seeking to dramatically increase industrial funding because of the cutbacks by federal dollars, and their policy is generally going to encourage their faculty to go out and consult with industry, as long as there's conditions imposed, and engage up and start up in entrepreneurial activities if there's conditions imposed. They're going to want to make sure that there's no interference with their university responsibilities, the limits on the total time that they can commit to these endeavors, limits on the use of the university's resources, making sure it's only incidental, disclosure from a conflicts of interest standpoint, and then obviously the compliance with all policies. When universities work with industry, the leverage for the industry is usually directly proportional to the caliber of the faculty member involved. So if you're entering into an agreement with a faculty member at MIT, you have no leverage whatsoever. MIT is going to dictate the terms. You want to do it? Good for you. MIT is going to dictate the terms. You probably have the best engineer and scientist minds in the world, so that's what you get. Universities that don't necessarily have the cash of an MIT may be a little more flexible in the negotiation process, but most of them are going to stick to their templates. So there's lots of different kinds of agreements. There's research agreements, there's executive education agreements, there's testing or service agreements, there's capstone agreements, there's visiting scientists agreements, there's outside activities like consulting agreements by faculty. There's lots of flavors of universities engaging with industry, and they all have slightly different terms and conditions associated with them. With a standard research agreement, generally the university is going to have a staff that's familiar with intellectual property issues. The IP clauses are going to be double checked to ensure by Dole compliance. Administration is going to inquire whether there are any background rights of the university or other researcher that need to be identified and segregated out so that they're not entering into conflicting licensing obligations, for instance, down the road, or that they're not jeopardizing a line of research by giving away rights that are necessary for the university to maintain a particular line of research. And administration should really be ensuring that the students' rights, if there's student involvement, are not being compromised in any way. Executive education agreements, these are agreements that are entered into when the companies talk to the university about providing training of some sort, and usually this is okay. So the company can own all the slides, the videos, the materials, but the faculty is generally going to want to make sure it reserves the right to use this material or pre-existing material in its own teaching responsibilities. The agreement would probably restrict the company to use the materials for its internal use, so it can use it for training its employees going forward. But this is going to be hard to enforce from a university perspective. And again, there's going to be a reservation of rights to the university and faculty member to be able to use this in education going forward. Testing and service agreements are becoming more and more common, especially in the biological arts. These are limited use agreements where the company simply needs the university to run some sort of a test on company-owned materials. So it might be a biological material, it might be genetic material, it might be a cell line. It's something that the company needs test results on, data. Run these tests pursuant to your protocols and give us the data back. There's generally not going to be IP that arises as a consequence of that. So generally with these testing agreements, it's okay that the agreement says the company is going to own all the IP because the university has assured itself that there's really no IP coming out of it. To the extent there's IP, it's just in the data itself, and they're okay not taking title to that data. So this is an exception where the university can grant the institution, the private sector institution, ownership. But the statement of work, again, needs to be drafted with really close attention to detail to ensure that this exception is not being abused. So they're not taking a particular protein sequence and then figuring out how to synthesize it, or figuring out from a cell line that it's useful in this test, and developing assays for all different kinds of tests. That's where IP does come in. It becomes more like a research agreement than a testing agreement. So you need to make sure that the limited exception is really not being abused here. Capstone agreements. Under university IP policies, do undergraduate students own the IP they develop? Most of the time, universities don't stake any claim to student intellectual property. So if a student is working on a research project, it might be a capstone project, generally the student is going to own any IP that arises from that, and they can do with it what they want. That's the way most universities approach student-created invention. Sometimes the students want to work with companies on capstone projects, and the company is willing to do that. And the company is going to demand ownership of it. Usually, the university is kind of an intermediary there, and they're simply telling the student, look, you can do this, enter into an agreement with them if you want, but get your own counsel and negotiate what you want out of this. But we're okay, we're not going to interfere with your ability to go and use a company sponsor for your capstone project. Visiting scientist agreements. Again, it can be either university to company or company to university. These are the key provisions that you would see in a VSA. What funding is that person going to be working under? What is the intellectual property that the person is bringing with him or her during the visit? Will the work relate to any funding at the university? What is the expectation for any intellectual property that's developed, and what are the time commitments by each institution? So again, VSAs are fairly common now because there's more and more collaboration. These are the standard terms. Consulting agreements, usually between a faculty member and the university, or the company. University is not a party to these consulting agreements, but there's important implications. It's useful for the company and the faculty to make sure that the university knows it's going on and says, yeah, this is fine, so that you don't get into a fighting match later on over what the obligations were. It's not effective for the faculty member to wait until the annual disclosure form to disclose that, because then they can't manage it. All right. We're right at the hour 15. So are there any questions that I haven't covered?
We discussed the concept that the university allows the students to I've encountered agreements, particularly with PhD students, where it's the exact opposite.
Yeah. I'm sorry. I should have clarified. When I meant students, I was talking about undergraduate students. PhD students that are working under research projects are generally, a lot of times, they're employees of the university because they're given stipends, they're given the tuition benefits, and they're working under funded research projects. But it's not typical for an undergraduate student to be under that kind of a situation, right? They're paying to be there and they're paying to learn and get their degree. So with undergraduate students and even master's level students, for the most part, generally the policies at the universities are that the university doesn't own the IP that comes out of those. PhD students are treated a little differently because of the manner in which they're at the university and their relationship with the university. Quite often it's an employment situation as opposed to just a student situation.
And does that PhD student negotiating for the rights to the IP that they create?
They could be inventors on it and be subject to the policies of the university pursuant to the sharing and whatnot, yeah. Okay, are there other questions at any of the other offices?
Yep, question in Rochester here.
Mm-hmm.
Just to go back to the testing service agreement slide.
Yep.
Assuming that there's no research component and no educational component here in a typical testing agreement, would you assume that the university would need to be concerned and take into account UBIT and not performing these types of activities in a tax-exempt facility?
Yeah, it's possible. Usually with those testing agreements, though, there is an educational component to them. So the university, for instance, is getting access to a biological material that it would never otherwise have an opportunity to experiment with and run tests on. So normally, and that should be part of the testing service agreement, is the indication of that mission benefit to the institution to protect the institution from having UBIT issues with it. So normally what you want to do on those agreements from a university's perspective anyway is to ensure that the language in the agreement is delineating what the mission benefit is to the institution actually carrying on that particular testing agreement. And like I said before, normally with these testing agreements it's because the university is having an opportunity to perform tests on something that it otherwise would not have the opportunity to do it, and so they're going to learn something as a consequence of that.
Okay.
Yes, a question here in Syracuse?
Yeah, how arduous is the process to get an exemption to license, research to a non-U.S. company?
Okay, so the question deals with when you're dealing with federal funds and you got bi-dole issues, how hard is it to get a waiver from the government funding agency to give a license to a foreign corporation or to assign to a foreign corporation? It's not necessarily the easiest thing in the world to do. You need to make a case as to why it can't be done with a U.S. company. So the technology that I was referring to when I was talking about the example of the spin-out company that we had licensed, the university had licensed the technology to, and then that company was bought by the European company. The U.S. spin-out company, while it was in business, it was really struggling. And the technology dealt with, it dealt with smartphone manufacturing. And the reason it was struggling here, there are 0 smartphone manufacturers in the United States. None. They're virtually all in Asia and Europe. And that was the case that was made, saying, look, this company, the spin-out company, can maintain its license and not sell, but it's going to go out of business, and we're going to lose the 15 or 20 jobs that we actually have here. If we sell it to this company, they've got the complementary technology that will really allow it to be exploited fully, and they've committed in this agreement to maintain employment in this area for so many years. So we made the economic case as to why it was important to receive that waiver, and it wasn't even in that situation. It wasn't even the easiest thing in the world. It still took a couple of months of back and forth with the funding agency to get that waiver signed. So the funding agency took it very seriously as to why it had to be done that way, and there really was no other recourse. So you can do it, but you need to make your case for it. Okay, any other questions in any of the other offices? One more question here in Syracuse.
How about the startup New York program that required at the beginning at least,
Mhm.
the industrial entity that was partnering with the state university put their location on the campus.
Yeah. So this is a question under Startup New York, and the requirement under the Startup New York program at the outset that the startup company place a facility at the university. I'm not sure that's still a requirement under Startup New York. In fact, I'm sure it's not. But they are, obviously, Startup New York is an economic development that's geared towards getting the research done at university facilities, right? SUNY Oswego does a lot of the Startup New York stuff now, as an example. To the extent there is a lot of, there's not a ton of Startup New York activity, but to the extent there is some, the SUNY system is probably the one system that's utilizing it the most. State government money is different from federal money in terms of the compliance, but the state laws generally have mirrored the federal laws to a large degree in terms of the restrictions that are placed on the use of the IP that come out of it. But they can also place these additional restrictions that are economic development restrictions by and large to guarantee employment in New York State when it's a state, New York State type economic development law like Startup New York is. There's one now. I just got an agreement across my desk yesterday, the day before, with I'm trying to think what the agency is. It's an environmental economic development stimulus in New York State. And part of that agreement is, if anything, any IP comes out of this from the university's perspective, it has to license royalty-free to any company located in New York State, which I hadn't actually seen that particular provision before. So now the company, and I'm actually representing the company in this particular instance, says, well, maybe we don't want the state's money. Maybe we just want to fund this entirely on our own, and then we'll negotiate our exclusive license later on, rather than using any state money as part of that research project, because that could be troublesome if it can be licensed on royalty-free bases to New York State-based companies. So, but there's lots of economic development stimulus plans in New York and every other state, for that matter, that are going to place restrictions that are tied to the economic development activities. Okay, any other questions? All right, well, thank you all very, very much for attending, and I hope it was helpful for you. If you do have any other questions after the fact, feel free to give me a shout or pop me an email, and I'm happy to answer any questions I can. Okay? Thank you very much.